Hey, good morning and welcome everyone to the Employment Law Seminar. I'm Eli Matthews, President and CEO of the Chamber of Medford and Jackson County. Hey, thrilled to open up this program this morning with our over 245 registered participants. Foremost, a special thanks today to our presenter, Sean Ray, partner at Barron Liebman. You know, as we all navigate this ever-changing landscape, it's imperative that we all are guided by our experts and stay in compliance moving ahead. So thank you, Sean, for presenting today. And thank you all for being here this morning to learn. And of course, this seminar cannot be made possible without our sponsoring partners. I want to take some time just to acknowledge and thank the Klamath County Chamber of Commerce, as well as the Grants Pass and Josephine County Chamber, the Bend Chamber, as well as the Redmond Chamber. We also have the Crook County Chamber and Sisters Area Chamber of Commerce. Also, a special thanks to our friends at BBSI for sponsoring this seminar and for all their engagement and dedication to our communities and businesses. Next on the screen for some remarks will be BBSI's Area Manager for Southern and Central Oregon, Joe Rossi. Joe, thank you for your continued support and all your contributions you do for our chambers and our business communities. I'll pass the screen over to our friend, Joe Rossi. Thank you.
Thank you very much, Eli, and I hope I can get on screen or I'm being heard on screen. And thanks so much, for the nice intro. Wanted to make sure, and on behalf of the entire BBSI Southern Oregon team, like to welcome you to our 2022 Employment Law Seminar, otherwise known by the acronym ELS, and presented by Barron Liebman attorneys. For those of you who have attended our ELS in previous years, this is BBSI's 7th year in sponsoring this event, and it's amazing how time flies and how many of these we've done. But as we come out of the two of the toughest business years that we've ever faced, this year's ELS will most likely be more important than ever to understand how your business will cope with the workforce management aftermath that's been brought on by the pandemic. In co-sponsorship with Barron Liebman, BBSI is obviously committed to helping our own 275 PEO business partners, many of whom are attending this event this morning, and then our local business communities as a whole to navigate through Oregon's increasingly complex employment law environment that has been impacted by the pandemic as well. Now, this year, as Eli's mentioned, we have a number of local chambers who are helping bring ELS to our business communities. Thank you to all of them once again that he mentioned. And for our first year, we're also offering ELS to our home builder association partners from Southern and Central Oregon. So it's good to have all of you with us this morning as well. Now, just a quick reminder about our virtual ELS format before we get started. If you've attended a Zoom webinar, you've likely encountered how this works. However, for those of you who haven't, I'd like to take just a few moments to explain how we'll conduct the presentation and the Q&A feature at the end of this program. As you've noticed, you are not on screen and you do not have video or microphone capabilities as a participant. We know that you're there. We can see how many are signed in and we can see your monikers, but you simply are a participant and a listener in this webinar. The chat function has been turned off for this presentation. We've experienced that unnecessary chats are very distracting to the entire audience. So you can ask questions to our presenter throughout the program by using the Q&A feature located at the bottom of your screen. This Q&A feature will be monitored by our BBSI Human Resource Manager, Sarah Lindsay. At the end of the presentation, Sarah will be reading through your questions for presenter response. So feel free to type in your questions as they come up, but know that we will not be getting around to answering the questions until the end of the presentation. The Q&A feature will be open for the entire duration of the program, even during the Q&A itself. But please understand that not all of our questions may be addressed due to time constraints. So we'll do the best we can to have Sarah get to as many questions as possible. After the ELS concludes, Baron Liebman and Sean will be distributing the presentation PDF to those names and email addresses that appeared in our ELS registration list. So that will be coming out. And finally, a recording of this presentation will also be made available on YouTube via the Medford Chamber website as soon as we can get it posted. So keep an eye out for that on medfordchamber.com, and you'll be able to get the YouTube link. Also, as an event like this doesn't just take place without a lot of behind the scenes work, I'd also like just to give a shout out of appreciation and recognition to Kira Savala at the Medford Chamber for all of her efforts and hard work to set up the registration website and the ELS announcements. And to our very own human resource managers at BBSI, Sarah Lindsay from our Bend branch and Scott Richardson from our Southern Oregon branch, who have put a lot of work into preparing this for our own partners as well. So let's get to the presenter introduction. You know, it's my pleasure once again to introduce our ELS presenter, Sean Ray, a managing partner with Baron Liebman Attorneys. Sean represents employer management in very complex employment matters and high stakes litigation. He defends employers against discrimination complaints, sexual harassment lawsuits and retaliation claims, wage and hour claims, and represents employers in state and district court, as well as before Oregon's Bureau of Labor and Industries and Washington State's Human Rights Commission. In addition to being well-versed in trial skills and high-profile litigation, Sean works with employers to ensure compliance with changes in employment law, including drafting and revising employee handbooks and providing customized trainings to address harassment and discrimination in the workplace. Sean's clients value his solution-oriented approach and his focus on long-term business success. As I mentioned, this is Sean's 7th year in presenting our ELS. He's kind of reached celebrity status in our region, but seriously, he is widely regarded by many as one of the top employment law attorneys in the entire state of Oregon. So with that, Sean, welcome again, and we'll have you take it away as I mute myself on this. So thank you so much.
Thank you, Joe, and welcome to everybody who's joined this presentation so far. Happy to be here sharing with you this presentation. I'll go ahead and share my screen so we can get into it. This morning, we'll be talking about a number of things in this employment law seminar. First and foremost, I'm going to go through some of the recent changes in employment law. That might be new statutes that have been passed within the past year, some new rulemaking or regulations that have come out, as well as some key cases that have been decided here in Oregon by the Court of Appeals that have an impact on the legal landscape here for employers and the way we advise employers to conduct, their affairs here in the state. After that brief update, we'll go into the best practices for managing employee performance, and then also, of course, should the performance not be able to be managed, then separating those non-performing employees and some of the risks to look out for there when you're engaging in that type of activity, as well as finishing up before we get to that Q&A with COVID-19 carryover that still is there, as well as, perhaps continuing requests to work from home and requirements for employees to return to work and all of those kind of things as we climb out of this pandemic that has changed the way all of you, I'm sure, do business over the past couple of years. We'll wrap up with a Q&A, and I'll try to leave a considerable amount of time. I know that we've got, as everyone said, close to 250 people here. It's probably going to be a lot of questions that people want to have answered. And so I'll try to leave a good chunk of time at the end to answer those questions. Just a brief reminder that the Q&A is not for, seeking legal advice. I am not your employer or your attorney at this time for employment purposes. And therefore, anything we talk about here is not privileged. I urge you not to disclose too much in your questions. If you have a hypothetical related to what we've talked about here, feel free to throw that out, but don't ask any specifics regarding employees you may have, because it's going to be heard by 245 of your closest friends here on this presentation, and it will not be privileged communication. So keep that in mind as we get to the Q&A portion of today's seminar. Start off with the employment law update. You'll notice I just got a giant 1 here, and this is being recorded. I myself am a patent attorney as well as an employment law attorney, and so being mindful of potential copyright issues and such, I've scrubbed all the fun pictures and those types of things we sometimes do in person. So apologies for the very bare bones slideshow presentation, but because this may be rewatched and reused multiple times in the future, I wanted to make sure we don't have any issues with that. So let's get into the employment law update and talk about some recent changes that hopefully you're aware of. And if you're not, now's a great time to become aware of them. Start off with House Bill 2474, which amends OFLA, Oregon's Family Leave Act. This is an amendment that is effective the first of this year, so just came out. Basically what it does is it allows a period of leave where your OFLA eligibility is not forfeit. And so if you have a break in service, you leave employment, but you return to that employer within 180 days or less, your OFLA eligibility is retained. So recall that you ordinarily have to work 180 days with an employer in order to be eligible for employment. In this case, if you were to work 60 days and then leave for 60 days, but then get hired back, you would still have those 60 days in the bank. You wouldn't have to start back over at 0. And so this new amendment allows for essentially a break in service for an employee, yet they still get to maintain their OFLA eligibility. Another prong of this bill that was passed earlier this year is that it relaxes the eligibility requirements for employees to be eligible for OFLA leave during a public health emergency. And in a public health emergency, the employee only has to be employed for at least 30 days of employment as opposed to the 180 days. They still have to work 25 hours or more per week on average during the 30-day period preceding the leave in order to be eligible, but the eligibility time frame for length of employment is shortened during a period that's considered a public health emergency. That was through June 30th, 2022. Since I've prepared these slides, I believe the governor has repealed her executive order, and therefore this part is no longer in play. But should the Omicron variant or something lead to another declared public health emergency, this would then these relaxed eligibility requirements would then be reinstated as well, to where employees are eligible for OFLA leave after a mere 30 days of employment, as opposed to the regular eligibility period under OFLA. So be mindful of that when you get a request from an employee for some leave that would potentially qualify as OFLA leave, and they've only been there for a month or two within the context of a public health emergency. Another aspect of it is that leave to care for a child of the employee who requires home care due to the closure of the child's school, the child's daycare, as a result of a public health emergency as well, is another aspect of these OFLA amendments. So again, in the event of a public health emergency where a child's daycare is closed due to that public health emergency, the eligible employee, assuming they meet the eligibility requirements, can take leave to care for the child who must stay home because of that closure of the daycare or of the school. And important note is that no medical verification is permitted for this type of leave. So you're not going to be asking for medical verification in order to grant somebody this type of leave to care for a child who needs the home care due to the closure of their school or daycare. However, in the event the school or daycare is closed, you can ask for a certain verification, right? It doesn't make sense to have a medical verification because in that instance, it's not sick child leave. It's simply that the school is closed for a public health emergency of some sort. And so what you can require is the name of the child who requires home care, the name of the school or of the daycare or childcare provider that is subject to the closure, a statement from that employee who's requesting the leave that no other family member of the child is willing and or able to care for the child during this time frame that the employee needs the leave, and a statement that special circumstances exist that require the employee to provide the home care for the child during the day if the child happens to be older than 14 years of age, right? So in general, this leave would only apply to kids that are 13 years and under, absent some special circumstances that the employee can articulate that requires them to provide care during the day to a child that's older than 14 years of age. And so you can require the employee to provide this information to you if they request to use the leave under OFLA for closure of a school or daycare due to public health emergency. Another bill recently passed, again, this one also effective the first of this year, January 1, 2022, is the Crown Act, which is aimed at a very discrete kind of race-based discrimination. And what this is geared towards is dress codes and those types of things. Discrimination as a point here does not include enforcement of an otherwise valid dress code or policy as long as the code or policy does not have some type of disproportionate adverse impact on members of a certain protected class to a greater extent than the policy impacts other persons generally who might be outside of that protected class. So as a reminder here, race includes physical characteristics that are historically associated with a certain race, including but not limited to hairstyles, natural hair, hair texture, hair type, protective hairstyles and such as defined under the Oregon statutes. You can find those in ORS 659A. That's the general statutory chapter regarding a lot of these employment laws is in that 659A chapter. And so that's where you find the definitions here for race and what it includes, including these various hair characteristics and hairstyles. Protective hairstyles further defined to be a hairstyle, a hair color, a manner of wearing hair for individuals that includes, but is not limited to braids, regardless of whether the braids are created with extensions or styled with some type of adornments or locks or twists or those types of things. And so, it's important to understand that, your dress code may need revisions to it if you have descriptions of what types of hairstyle may be appropriate or inappropriate in the workplace if it encompasses one of these quote unquote protective hairstyles that's now covered by the Crown Act. So as a matter of homework, if you will, following this presentation, I urge all of you to pull up your employee handbook. Hopefully everyone has an employee handbook. If not, we should have some bigger conversations going forward, but pull up your employee handbook and have a look at your dress code policy to make sure it doesn't potentially run afoul of the Crown Act on its face, because that would be Exhibit A if you at a trial or in a BOLI hearing, if you were to discipline somebody for a dress code violation that on its face explicitly violated this new Crown Act that's now in play here in Oregon. So, a little bit of work to do after the fact, just as sort of a best practices suggestion for all of you. Another House bill recently passed is that the Pay Equity Act that came out a few years prior was amended to allow incentives related to COVID-19. And so recall that, pay equity really does govern certain incentives and what you can and can't offer, because that would be included in potentially compensation, which then may cause inequity with respect to certain employees of different genders or different classes. And so this new bill that came out explicitly excluded, from the definition of compensation, vaccine incentives. And so this one is from last year, effective almost a year ago now, but it allows for employers to offer vaccine incentives to employees, paying them some amount of money if they get a vaccine for COVID-19. And that incentive that you pay them is excluded from the definition of compensation, such that it wouldn't be seen as a quote unquote pay bump to those employees who accept the incentive and therefore go ahead and get vaccinated. Also, employers can offer hiring bonuses and retention bonuses, and for a certain period of time that just expired, those bonuses were excluded from the definition of compensation. So any bonuses or anything you paid out won't factor into pay equity analyses moving forward, provided they were done between May 25th and March 1st of this year. And so, again, that really came about because of the issue a lot of employers had with either retaining their talent, who were thinking about perhaps, quitting their job and then just collecting unemployment, or as well as hiring the talent necessary in a very competitive hiring market because so many people were out of the workforce at the time. And so those bonuses that were paid to individuals in order to maintain a competitive advantage within, the industry can be excluded from the definition of compensation, such that if you're looking at a pay equity analysis this year in order to determine whether or not you have any potential issues there with your pay structure, be mindful of the fact that any of those hiring bonuses and retention bonuses during this period, during this window, can be excluded from the compensation, such that those should not skew the amount of pay that certain individuals had if they did receive either a hiring bonus or a retention bonus, which is good for employers. Another regulation that came out, this one not a bill, so not a statute that got revised or a brand new statute, but more of a OSHA rules that were proposed, have not gone final yet, last I checked, but I anticipate that it's going to be by the end of this month, maybe early next month, that they adopt them. They did have the rulemaking hearings on them in March, and so those have been closed. But ultimately, this is a proposed rule geared on the temporary rules they had last summer during the extreme heat wave we had, as well as the wildfires that we had, a while back as well, that were really bad and caused a lot of wildfire smoke issues. And so we'll jump into sort of what these look like. Ultimately, the extreme heat rules. So we have basically two prongs here to this. We have the heat rules, and then we have the wildfire smoke issues. And so the extreme heat rules apply to any workplace where heat dangers are caused, by the weather. I've got a link there to what the proposed rules look like there. It's a hyperlink. Obviously, you can't click on it right now. It's just sharing my screen, but it'll be in the materials if you want to pull that rule up yourself to kind of take a look at what exactly it entails and what it means. There also is expanded measures under federal OSHA with respect to a national emphasis program on heat inspections. And so recall that, Oregon has its own OSHA, state OSHA, that is required to be as protective or more protective than federal OSHA. And so, those rules and measures with respect to what federal OSHA does generally will be tasked with Oregon's state version of OSHA with respect to inspections and enforcements of that. Generally, what the rules break down to is that when the heat index here in Oregon, in your location, wherever you may be located, is greater than or equal to 80 degrees, employers have to provide sufficient shade that's immediately available and the adequate supply of cool drinking water to employees. Generally, again, this is going to apply to certain workforces that are working primarily outside as opposed to inside in buildings that have adequate temperature controls and easy access to drinking water. So this is going to be more applicable to construction industry, agriculture industry, those types of things where you have people that perhaps are working outside more so than inside. When the heat index is greater than 90, employers have additional obligations that they must follow as well. They have to still follow those two regulations for the 80-degree heat index, but they also have to have effective communication system that puts workers in contact with supervisors as needed, essentially a reporting requirement that employees can tell somebody, hey, I don't feel well, hey, I need more water, hey, anything else they need, so that there's a effective communication system so that they can get assistance or help or medical need attention if needed. You have to designate one or more employees and provide them with sufficient equipment to call for emergency services if necessary. So, if you're working out there remote somewhere where you've got spotty cell service, you're going to have to provide equipment, that will still allow via satellite or some other method for an employee who has been designated by the employer to call for emergency services should one of the employees in that location need some type of medical attention. You also need to have a heat illness prevention work or rest schedule that's adjusted for effective protection. And so you'll need to be scheduling certain breaks in order to prevent employees from having the onset of some type of heat illness, whether it's heat stroke or heat exhaustion or what it is. You need to have a work schedule / rest schedule where you incorporate enough breaks in there so that employees do not come down with any type of heat illness there. There is exemptions in this rule for incidental heat exposures where the employee is not required to perform work for more than 15 minutes in any 60-minute period. This is perform work outdoors again. So if you're primarily an indoor employer, then these rules don't necessarily apply to you, provided you don't have employees that are required to perform work outside for more than 15 minutes in any 60-minute period. So if you're primarily inside, but they need to go outside for 20 to 25 minutes during that hour, you're going to need to comply with these regulations for those employees. If it's an office employee, a bank teller, something like that, then you're not going to end up finding these applicable to you because there is an exemption there. So you'll likely be exempt from those. You'll need to, if you are subject to these rules, once they become final, you'll want written plans and procedures that you can gradually adapt employees to working in the heat. Essentially, it's an acclimatization to the weather. It's a preventative measure that you'll have to look at considerations such as personal environmental risk factors, workers' activity levels. What type of activity are they engaged in outside? Is it highly aerobic type activity where they may become fatigued and suffer heat stroke more quickly than somebody who's fairly sedentary, perhaps more easily able to work in a shaded environment outside? And so some of these various risk factors will go into a written plan and procedure that you'll have to adopt to gradually adapt employees to working outside in the heat, particularly an employee who perhaps is transitioning from an indoor workplace to an outdoor workplace. If they've been working inside for 2 years in a climate controlled zone, and then you send them out into the heat and it's 105 degrees outside, you might run into some issues there. And so you'll want to, if you're transitioning somebody to an outside working position, know that you'll want to acclimatize them to the extent you can by perhaps allowing them more breaks until they get adjusted to working outside in the heat. You'll also need a written heat illness prevention plan that spells out what's going to be done to protect employees and what type of services, tools, equipment, et cetera, is made available to the employees. Similar to how you might have other types of safety plans. Recall that we were required to do this at the onset of the beginning of COVID-19, when we had to have our written plans with respect to how we were going to keep the workplace safe via sanitization schedules and those types of things. And so this is another essentially another written plan that you'll need to adopt, spelling out the protections you as an employer are taking to keep these employees safe. And you'll also need to provide annual training to these employees, as well as information to employees and their supervisors in a language that's readily understood. So again, if you're in an agricultural industry where more than half of your employees are native Spanish speakers, you're going to want annual training and the written prevention plan and all those other key documents translated into Spanish for them so that they can understand what's expected of them when they're required to report to a supervisor about their own heat-related situation and those types of things. So you'll want to make sure, again, if you are subject to these proposed, which should be final fairly soon, extreme heat rules, that you get to work on creating a written prevention plan geared towards preventing heat illness, as well as providing your annual training and information in whatever language is readily understood by your employees. It's a good time, to do it now while we're still in April, going into May here, before we get into the middle of summer, when more of these situations will arise where the heat index is at or above 80 degrees for workers who are outside. There's also a proposed wildfire smoke rule under Oregon OSHA. As I mentioned, both of those have gone through the rulemaking process. There was a public comment period, which has been closed, as well as some hearings on those rules, which likely we anticipate will be adopted fairly shortly by OSHA. And what this is similar to sort of the heat rules. It goes off of a metric, whereas the heat rules go off the heat index. This wildfire smoke rule goes off the air quality index, and it essentially applies when employees are exposed to wildfire smoke and the air quality is greater than or equal to 101 during that period of wildfire smoke. Again, there's an exemption here for certain employers. For example, if your employees work in enclosed buildings where air is filtered by a mechanical ventilation system, and the employer ensures that certain exterior doors and windows and everything are closed during this period of poor air quality and wildfire smoke, except when necessary for employees to enter or exit the building, then you would likely be exempt from this wildfire smoke rule. But again, if it's an outdoor type of job, construction, agriculture, if it's a job that's partially outdoors, again, such that it wouldn't necessarily fit within the exemption here regarding always working in an enclosed building with the air filtration, it's perhaps 40% indoors, 60% outdoors, or 60% indoors, 40% outdoors, you may still nonetheless need to comply with this rule. And as we look at sort of this rule, I found it helpful to pull up sort of the AQI reports for the past 5 years or so. And if you look at this, and it's you can go ahead and access this yourself on the EPA website. It's down there at the bottom where I have the source listed there. But if you look at this just in general, what are we talking about here? If this applies when there's wildfire smoke and the air quality index is 101 or greater, how many days of the year are we going to have to potentially comply with this rule? And so if you look at Bend on average over the past 5 years, that's 12 and a half days. Grants Pass, 19 days. Medford, 22 and a half days. Klamath Falls, over 25 and a half days. The farther north you get, Salem's only 5.5 days. Eugene's 9 days. So, Southern Oregon, definitely more impacted in the recent 5 years or so by wildfires and wildfire smoke, either in Oregon or even drifting up from California, such that it may be something that you'll have to comply with 20 to 30 days per year. So definitely not insignificant there. Obviously, the stricter requirements that are required once you're over 250 AQI, of course, or a one even over 500, much less significant or less impactful on employers. As you can see, in Bend, the 5-year average is less than half a day where you're over 500. Grants Pass has been 0 days on average and such. So the stricter requirements are going to be less, hopefully based on statistical averages and history, less impactful or less common than the lower restrictions, which kick in after you exceed 101, which is going to be your more common aspects for the air quality index. And so, again, if you want to pull your own numbers, it's a good exercise to kind of take a look at, in my location, how often am I going to need to comply with this type of rule? So let's get into a little bit about what the requirements are for these wildfire smoke rules that are proposed and are likely to become final soon. First and foremost, employers would need to determine and monitor the employee exposure at the start of each shift using certain methods to gauge appropriate exposure controls based on what the air quality is and what the potential exposure is to the employees during that shift. Again, you also need, like the heat rules that OSHA has proposed as well, have to provide annual training and information to all employees who may be exposed to the wildfire smoke during the course of their workday. And again, that's should be provided to those employees in the language they are most likely to understand. Again, if they're native Spanish speakers, you'll probably want to provide that training in Spanish to them so that there isn't any concern that perhaps they don't understand what they're expected to do by the employer, and they don't potentially do something improper or wrong, leading to injury or something that may present as liability for the employer. Employers will also want to develop and implement a system to communicate the wildfire smoke hazards before the exposure occurs, so that the employees know what the expectations are, right? The employees may not be checking the air quality index on a daily basis prior to showing up to work. They don't know whether it's at 249 or 251. And if it's at 251, it's potentially different requirements. And so you'll want to develop a system to communicate what those hazards are, particularly during perhaps wildfire season, that, hey, today's air quality index is this, or it's expected to be this. Therefore, we need you to comply with X, Y, or Z, depending on what you've established as your protocols to eliminate or reduce these smoke hazards that employees may be exposed to during wildfire season. So if we're at an air quality index of 101, you're going to need to use engineering or administrative controls to reduce the employee exposure to less than an AQI of 101, right? So that's sort of the threshold is air quality index of 101. If we're below that, we're fine. If we're above that, you need to use engineering or administrative controls to reduce the exposure to a number that's less than 101 on the air quality index. Engineering controls could be having them be in an enclosed building or in an enclosed vehicle where air can be adequately filtered through the filtration systems, the ventilation systems that you might have in your car, in your vehicle, or in your building. You also might need to engage in administrative controls that include relocating work to another outdoor location with better air quality if possible, or changing work schedules. If it's a kind of situation where the air quality is only going to be poor, for the morning, and then the wind's going to pick up and kick out some of that smoke, and it's going to lower back down. You may have to change the work schedules to shift work to later in the day or something along those lines. And so you are going to be required once these rules become final to use some type of controls to try to reduce the employee exposure to a level that's below 101. You're also going to need to provide employees with some type of filtering face piece respirator approved by NIOSH, the National Institute for Occupational Safety and Health, for voluntary use when exposure equals or exceeds an AQI of 101. And as we mentioned, that's, potentially 20 to 30 times per year based on your location according to, historical averages over the past 5 years. Essentially this is N95 masks, right? So you're going to want to have N95 masks. Hopefully you have some left over from COVID-19 that you might have been providing to employees, at that time. But at any rate, you're going to need to have some N95s on hand for outdoor employees that would be subject to these new requirements for prevention of wildfire smoke exposure, so that you can provide them to them. Again, it's for voluntary use. So this isn't equivalent to, the face masks on the airplane where you're going to have to pay somebody to walk up and down the aisle saying, put your mask back on, put your mask back on. This is for voluntary use. If they choose not to use it, that is on them at lower levels. And so ultimately, if it gets up to 102, you want to make sure you have adequate N95 masks available for use for them, for employees. And if it's not fully available location so that they can get them, obviously if they're working, 100 miles away somewhere, you want to make sure they have them available at the work site so that if they want to use them or need to use them, they have them available at the place they're working. And if once we get above 250, so we're at 251 or higher, you have to then start ensuring that employees wear the N95s at that point. And so ultimately, again, between 101 and 250, it's voluntary. You don't have to mandate anything. It's up to employees to use it or not. Once we hit 251 or above, you need to ensure that they start doing it so that, they are adequately protected. For respirators that are used exclusively for wildfire smoke, employers can implement a wildfire smoke respiratory protection program, which is in the rules proposed appendix. Again, I've got the link in there in the materials here if you want to click on that and see what the wildfire smoke respiratory protection program looks like. But ultimately, it's an alternative to conducting medical evaluations and fit testing under the respiratory protection standard for N95s. Perhaps some industries have already, based on the nature of work, already done fit testing for N95s and other respiratory protection controls that they use, if they're spraying toxic chemicals and those types of things. But for people that have not done fit tests on employees because they don't regularly use respirators outdoors, perhaps they're just building houses, and you're just hammering nails into wood. You're not really exposed to anything, and therefore you're not wearing N95s outside. But if you're working outside, building a house in an air quality index of 260, you're going to need to start having employees wear these N95s under this final rule, and therefore you're going to have to go through either the fit testing under the respiratory protection standard, or you can implement this wildfire smoke respiratory protection program that they've included as an alternative for you in the index to the proposed rule. And then, of course, if we're at the highest mark, the over 500 mark, you have to ensure that the employees wear the N95s as well. And then you have to comply with the respiratory protection standard. You have to go through the medical evaluation and fit testing and such for those filtering face piece respirators that have, some type of canister on them to make sure it's filtering the appropriate amount of wildfire smoke out of the air for these employees. So you won't be able to get by with the wildfire smoke respiratory protection program. That's the alternative for when it's AQI of 251 or greater once it gets over 500. Again, over the past 5 years, very infrequently has it been over 500 in any of the locations where you all are sitting today. But it's important to note that if it does get really bad, you may need to go through these protocols. Of course, you may just opt to cancel work for that day. If it's only going to be one day in a year, maybe it's more cost effective or cheaper just to not have anybody work during that day if it's simply a day. On the other hand, when you're talking about 20 to 30 days a year, which is what it likely will be for 101 to 251 or greater, then canceling work for a month is less attractive to an employer, and perhaps you're going to have to comply with the lower level. But again, what we'll need to do is for employers that have employees who work outdoors, who work outside, we're going to have to start monitoring air quality index, particularly during wildfire season, to ensure we're meeting the appropriate standard based on which of those three levels we're at: 101, over 101, over 250, or over 500. Another frustrating statute that came out last summer is Senate Bill 483, which created a presumption of retaliation when you terminate an employee. So essentially, it's a rebuttable presumption, but nonetheless, it's a presumption. So it basically shifts the burden to the employer to prove it's not retaliatory if you terminate somebody or take other adverse employment action against them within 60 days of them engaging in protected activity. So for example, if they lodged a safety complaint, about unsafe working conditions, if they participated in an investigation, if they reported something they thought was, discriminatory or harassing, or if they filed a workers' comp claim, and you fire them or demote them or take some other adverse employment action against them within 2 months of them doing that, then the presumption is that your reason for doing so is retaliatory for that protected activity. You then need to rebut that presumption with the preponderance of the evidence, which means it's more likely or not that it was not retaliatory. Essentially, it's shifting the burden to the employer to prove they didn't do anything, as opposed to how it used to be, how it should be, which is that the employee should have to prove that something did happen. So essentially, in any action brought for this, there's a rebuttable assumption that a violation of this section has occurred if a person bars or discharges an employee or prospective employee from employment, or otherwise discriminates against an employee or prospective employee within 60 days after the employee or prospective employee has engaged in any of their protected activity. So that's the language of the statute. It basically means you've retaliated against them unless you can prove you did not do so. You can rebut it again, as I said, but that standard is preponderance of the evidence. It's not beyond a reasonable doubt, which people think of in criminal context. You see that on TV, and that's a lot more interesting to have on TV than the preponderance of the evidence, which we have in these civil cases, which is essentially 51%, right? It's more likely than not that this person is correct as opposed to the other person, or it's more likely than not that this happened. That's preponderance of the evidence. That then creates the burden employers have to meet in order to prove that they did not retaliate against an employee who now has that presumption of retaliation if that action is taken within 60 days of that protected activity. So again, that's something to be mindful of as you decide what actions, if any, to take against employees, particularly ones that have engaged in that protected activity. And we'll talk a little bit more about that in the next section when we talk about managing performance issues with employees. But here's sort of what the jury instruction we give here in Oregon is with regard to what preponderance of the evidence means. And I just have that there for you if you want to kind of look at what exactly it is. But essentially it's party must persuade the jury by evidence that makes them believe the claim is more likely true than not, right? Again, it's 51%, it's 50.1%, 49.9%, right? It just has to tick over that 50% line in order to meet your burden. And so again, that's the standard, but what it's essentially doing is this statute is shifting the burden onto the employer if you take those actions within 60 days. So, 2 years ago, you would go to court and the employee would have to prove that by preponderance of the evidence that you retaliated against them. Now you go to court, if you've fired them 30 days after they filed a workers' comp claim, you have to prove by preponderance of the evidence that you did not retaliate against them. And so it's a burden shifting statute. Ultimately, don't think this means that you have a get out of jail free card if you wait till day 61 and get rid of them, right? At that point, you just lose the presumption. They can still prove, but again, the burden shifts back to them essentially to prove at day 61 onward that the action was retaliatory against them for engaging in that protected activity. So this 60 days isn't necessarily your 2-month waiting period before you fire somebody because they engage in protected activity. It's just where the presumption of retaliation goes away after that point. So certainly safer to wait until day 61 to do that type of activity. But again, it does not insulate you from potential liability because the employee can still allege a claim. They can still file a bully administrative action. They can still file a civil lawsuit against the company. It's just that they, as in the good old days of a year ago, will have to prove their case by a preponderance of the evidence. Again, it's not necessarily a free-for-all. It's not creating some roadmap for employers that you should fire everybody who files a workers' comp claim 61 days after they did so, because it's not going to protect you from liability if the employee can prove by a preponderance of the evidence or can demonstrate to a jury by a preponderance of the evidence that the conduct was in some way, shape, or form discriminatory or retaliatory against that employee. So be mindful of that. It sort of changes the game a little bit for employers when taking action against somebody who happens to be out on a recent leave due to workers' comp, due to medical situation, et cetera. You also have an extension of the statute of limitations here for anti-retaliation protections in House Bill 2420. This again was also effective the first of this year. And what it did was, this one isn't as big of a deal. It just extends the timeline to file bully complaints related to retaliation for reporting unsafe working conditions or workplace safety concerns from 90 days to 1 year. So previously, an employee had 90 days to file a bully charge regarding unsafe working conditions. Otherwise, they lost that right. They could still file a civil suit, but they could not file a bully complaint. Now they have a full year to file the bully complaint, as they do with respect to all the other discrimination and retaliation complaints they can bring. So, be mindful of that extension as well. The best practice for all of these things that we've been talking about here is to document. Document your decision-making process. Don't plan to rely on testimony only. Again, it might be your burden if it's done within 60 days. So if you're going to rely on testimony only in order to prove your preponderance of the evidence, you're going to have an uphill battle there in front of a jury. So you're going to want to document. We'll talk a little bit more about documentation again when we get to managing workplace performance, but you're going to want to document who's involved, what happened, when it happened, what other evidence is there that proves your case or that you're relying on in making your decision. What other witnesses were there? Frequency of these occurrences, if it's repeated behavior, that type of thing. So again, best practice is always to document. I can't tell you, anytime I think in the past, 15 years of doing this, that somebody's come to me and said, hey, I didn't document that termination. And I said, great, that's going to work out really well for us. We always want the documentation of it. It's going to establish what happened. Oftentimes it'll get the timeline back in front of whatever the protected conduct is to allow us to get around this presumption that there's some type of retaliatory or discriminatory conduct going on. If we can show the decision was made 3 months prior to the filing of the workers' comp claim, we can get around sort of this inference that it's somehow related to that, since that had not occurred by the time we made the decision. So best practice is always recommended to document your disciplinary discussions, investigations, involvement, actions, etc. There's also a new driver's license requirement, or I guess non-requirement. It's Senate Bill 569, also effective the first of this year. It prohibits an employer from requiring a valid driver's license as a condition of hire. And so, you can't simply require a driver's license. I've had clients that say, hey, we run background checks, and that includes, DMV checks on these people, and they can't run it without a driver's license. You do have a carve out here. If the ability to drive is an essential function of the job, if you're hiring somebody that's a driver, absolutely you can require a valid driver's license. If it's related to a legitimate business purpose, you can also require the license. So I ask clients, I say, listen, is this person required to drive, or can you articulate for me a legitimate business purpose that you need to know this person has a driver's license? And if the answer is no, then just don't require it. Take it out of your job postings, take it out of your job descriptions for any position that it's not required for. As a reminder, federal law, when we're filling out the I-9, we can't require a driver's license there either. We can only require a List A document or a List B and List C document. The documents from those lists are up to the employee. It's not, employer can't say, I need to see X and Y. It's up to the employee to provide what 2 documents they want to, or 1 if it's a List A document. So, we already were restricted from requesting driver's license for certain purposes under federal law, the I-9 purposes. So again, if you're requiring a valid driver's license just because it's something you've always done, revise that unless it is actually a essential function of the job. And if it's an essential function of the job, then make sure it appears in the job description that driving is an essential function there. And that way you will protect yourself from liability for a violation of this new law here. Another area the legislator's been chipping away at, over the past this number of years is non-competition agreements. They clearly don't like them. And so they've been whittling away at trying to make them obsolete here. And so they're no longer voidable now. They're just plain out void. It's automatically void. It's not that the court can void it. It's that it's automatically void. And so that's, if you don't follow these, the steps, you don't jump through the proper hoops for a non-competition agreement, then your agreement is just plain old void. The threshold for it is that an employee who is bound by one of these non-competition agreements needs to have an annualized gross salary and commissions of at least $100,533 at the time of termination. This amount will go up. It'll automatically increase according to the CPI for all urban consumers West region. It's published by the Bureau of Labor Statistics of DOL. So every year that'll adjust. There is a limited exception if the employer is going to make certain payments to the employee during the period of non-competition. So if it's a very valuable employee and you want to make sure they don't compete for anybody out there because they might leak your secrets, and you just agree to continue their salary for the period of non-competition, then it doesn't really matter whether they hit this threshold or not. But again, you're basically going to be paying somebody to not work for you. So be mindful of that. But there is that limited exception if you are going to be paying them a certain amount of money during the period of non-competition. You may not have to meet that minimum salary and commissions threshold. You do have to provide a copy of the non-compete within 30 days of separation to an employee. Otherwise, the agreement you had them sign at the beginning of employment will be void. So again, that's a thing you just have to get in the habit of doing. Ultimately, it's probably a best practice anyways to provide copies of any agreements that are going to survive termination. If it's a confidentiality agreement, if it's a non-solicitation agreement, if it's any type of agreement that you want to make sure the employee knows is still in force and that you want them to abide by, best practice is just to provide it to them at termination anyways. Hey, just a reminder, you're bound by this still. The maximum duration has been cut down from 18 months to 12 months for a non-competition agreement. And that only, again, applies to agreements entered into on or after the first of this year. So it doesn't affect agreements that were already in place. Okay, so if you had an agreement in place and it was for 18 months, it doesn't automatically knock 6 months off the end of it or anything like that. These new rules apply to new agreements that you're entering into, which is a good time. If you're going to use one for somebody, then make sure you've looked at it and made sure it meets the recent requirements. The other elements, of course, under non-competes that we've always had to comply with for the past several years are still required. They have to be an exempt employee, generally white collar exemptions. You have to notify them at least 2 weeks before the first day of employment in writing that a non-competition agreement is required as a condition of employment, or you can present it to them on a subsequent bona fide advancement if you did not get them to enter into one at the start of their job. And where this may come into play would be if you hired somebody and they made $80,000, they didn't meet the threshold, and then you gave them a big promotion to where they're now over $100,000. You want them to engage in a non-competition agreement. That would be a time when you could enter into a new one at that point. But otherwise, you can't have somebody sign one after they've been employed for you. Ultimately, there's a executive order here encouraging the FTC to curtail the unfair use of non-compete clauses. Number of states just despise non-competition agreements and don't want you using them. So they've been whittling away against them. The legislative climate appears to be that we're going towards a complete elimination altogether. So ultimately, the best practice is just to only use them if you need to use them and make sure they're updated and tailored appropriately. If you can get by with using a non-solicitation agreement instead of a non-compete that has less restrictions on it, I think you should go that route. Not everybody needs a non-compete. I know I've seen people that just use non-competes for everybody. Make sure your employee is somebody who you need to restrict from working for some reason. If you've hired some vacuum salesperson, make sure you want them not competing in vacuum sales, such that you're going to take away their livelihood through a non-compete. Maybe you can do it by restricting who they can sell to, their vacuums with a non-solicitation, right? It's, you're taking away somebody's ability to sell vacuums, regardless of who they sell them to, even if they're selling to people you're not selling to. They've already got it hard enough, selling a product that sucks. So it's, come on, listen, my kids tell me that all my jokes are dad jokes because now I'm a dad. So if you don't like the dad jokes, you might as well just log off now, I guess. But ultimately, make sure you're using these. We should have a laugh track on this thing. I would know if people caught what I was saying or not. But ultimately, make sure if you're going to use a non-compete that it's for a specific purpose, an articulated purpose, not just because we always do it, because our competitors do it. Those reasons aren't valid, good reasons. Let's make sure you actually want to use that and need that, and that we can't get that protection or enough protection through some other agreement, such as a confidentiality provision, a non-solicitation provision, those types of things, that you really can't have this person competing against you for some purpose. And so that way you won't find yourself having to litigate these issues with non-competes because those tend to get, frankly, pretty costly. There's also a recent NLRB General Counsel memo that they have an initiative to try to issue injunctions, or seek injunctions rather, I guess, seek injunctions from the NLRB against employers and unions in federal courts to stop unfair labor practices. And why this is important here, this is just a memo that came out a couple months ago, is that we've seen lots of union organizing in Oregon, but in the Pacific Northwest in general. And so if there's talk of a potential union organizing campaign or something in your workforce or in your industry or those types of things, and you threaten or coerce an employee during some type of organizing campaign, they can step in and try to seek an injunction against the employer to stop any type of unfair labor practices, and they're going to be paying closer attention to that. So it's be mindful of those types of activities. If you do happen to start hearing about potential union organizing or seeing, some type of potential union organizing in your workplace, I urge you to reach out to your friendly neighborhood employment lawyer to ask, hey, what can I do? What shouldn't I do? What should I do? Because you don't want to step in something that gets an injunction against you from the NLRB. A case, we'll get into a case here. I said I'd talk about statutes. I said I'd talk about rules. We've done both of those. Let's talk about a case here, a pretty significant case that, it's a state court case that really undoes some of the district court cases. The federal courts that have looked at this Oregon statute have found one way, which is favorable to us, to employers and employment law attorneys that represent employers. And now we have the Court of Appeals going the other way and making this a completely expansive, interpretation of the definition of the statute. And what this involves is the old aiding and abetting statute under Oregon law. So as a refresher, the Oregon statutes, and I have it there in the header, 659A.0301G is the statute where this is found. And what that says is that you can proceed in a civil action against any person who has aided or abetted an unlawful employment practice. And generally this is used to individually name a supervisor, a business owner, those types of individuals in a lawsuit against the company. What this case, I'll just cut to the chase, I guess, and tell you that the spoiler alert here is that the Oregon Court of Appeals held that anyone, including a non-employer corporation or individual, can be held liable for aiding or abetting unlawful employment practices of an employer. And so what we had here was a plaintiff nurse. She was a nurse. She suffered a workplace injury that required an extended medical leave so she could recuperate and undergo a surgery to remediate the injury. The employer engaged a third party to manage employee medical leave requests and all of that kind of thing, floated those responses to a third party they contracted with. And then when the nurse sued, she sued not just the employer, but also that third party that managed the medical leave requests. And the Oregon Court of Appeals looked at the statutory definition. They looked at this legislative history of this statute going all the way back. And they basically found that a person, a quote unquote person as defined in the statute, can include anybody. They could be customers, they could be co-employers, third-party benefit administrators, third-party HR coordinators, employee recruiters, background check providers, etc. All of those individuals are technically considered a person under the statute, and therefore can be held liable for aiding and abetting should they be involved in something that leads to a lawsuit. And so, ultimately, huge potential issue here for roping in all of the HR consultants and all of those types of individuals, as potential aiders and abettors moving forward. So be mindful of that as you're, considering or contemplating taking action, as well as when you're re-upping your employment practices liability insurance, taking a look at who's covered under that policy. If a suit was provided, does your insurance cover these third parties that you're contracting with that may be named as aiders and abettors? If not, do they have their own insurance? Should you be asking or recommending to them they have their own insurance for that type of thing? So just be mindful of this case. They came out last year from the Court of Appeals, expanding essentially who can be an aider and abettor under the law. Froze up here. Right. Pardon me while we take these technical difficulties here, and I'll reshare. All right, we got it back, I think, if it'll go past. All right, so let's get into the second topic that we're going to talk about today, which is best practice for managing performance and or terminating underperformers. So, the keys to documentation that I really talked about is, this need to develop a paper trail. We really like to see evidence of, we being employment attorneys, but also jurors, when you're telling them their case, like to see evidence that this is an ongoing problem. Certainly, if it was an ongoing problem, you would have written it down somewhere. You would have some sort of documentary evidence that it actually happened. And so, documentation is necessary in order to develop that paper trail that can be used as evidence of why you made a certain decision. Form is less important than content with respect to documentation. There isn't a certain form you have to do. It just needs to be written down in a way that can be, that you can show that you made this decision at a certain time. So it's important to also date that document. Where do you keep it? Personnel file, maybe a supervisor's file, but just ensure that the formal file is complete. Employees have a right to inspect their personnel records. You want to make sure those disciplinary type documents are in there. When do you document? Often repeated problems that you've already addressed need to be documented, that it's still happening. Repeated problems that you have not addressed can be documented as well. When you write it down, you can reference the history of the behavior that you failed to write up initially, and therefore you can preserve it in that regard. And so document those. Serious performance or behavior issues should be documented. Workplace, what we call workplace sins that can hurt others, drug, alcohol violations, workplace violence, harassment, those types of things certainly should be documented. Should employee get a copy? I just, as I mentioned, there is a statutory obligation for an employer to provide an employee with the ability to look at their personnel records upon request. So it's never a bad idea. I guess not. I would say never. I'm going to avoid absolutes. I'm going to recommend you also avoid absolutes. It's rarely a bad idea to give an employee a copy of a disciplinary document. They oftentimes in litigation will say, I've never seen this. I've never heard of this. Nobody ever told me about it. So giving them a copy of it, certainly can try to help negate that type of storyline they might be relying on. Assume it will be read by others. Because again, this might be Exhibit A if we have to go to litigation. So be professional, be complete, be honest in your assessment of the issues. Don't be too casual. I know we're kind of in a casual world this day and age, but I don't want to see Snapchat discipline, text message discipline. if you have to text somebody something, let's make it a little more formal, with a little less shorthand in there so that everybody can understand what you're actually saying. Again, there's no form, content's more important, but, oftentimes text messages and things aren't saved routinely. And therefore, when you get a new phone, you've lost all of your disciplinary documents and your correspondence and such. So to the extent you can be a little more, formal, if you will, that can be helpful. So, as I said, be thorough and complete. You got to date it. Don't backdate it. Even if you're recounting things that happened previously, you want the date of the document to be the date you prepared it. So if you're preparing a document on April 26, 2022 for behavior that happened on April 21, I'm not going to date the document April 21. I'm going to date the document April 26 and say on April 21st, this occurred. You want the date documentation to establish when it was done so that you can then get in front of protected activity to the extent you need to. As I mentioned, you can incorporate previously undocumented history if needed. If this is the third time the employee's been late and this is the first time you've written it up, you can say, this is your third absence. You were also your third tardiness. You were also tardy on these two dates, and we spoke about it with you. This is a written warning now. You can use and reference supporting documents to the extent you have any, or there are any supporting documents. If it's a social media harassment type claim and you have a copy of the harassing post or the harassing DM or whatever it is, you can certainly reference that in there. Keep that as well in the file to the extent you have that too, because that's going to be important as well to corroborate the written discipline. Progressive discipline is an approach that a lot of employers use. What it is the process by which the penalty becomes greater for each subsequent infraction. So a typical process may be a verbal warning for the first time that behavior occurs, a written warning after that, and then suspension and termination. At some point, you might engage in a performance improvement plan with the individual, laying out what the deficiencies are and what you need to see them improve. Ultimately, what you want to do is just be consistent and follow the handbook or your CBA if you have a collective bargaining agreement due to a unionized workplace, because you might be required to engage in this, and or have just cause if you've got a union. But ultimately, typically you're reserving the right to skip any of these steps in a progressive discipline process, but you want to be consistent, right? It's where you run into problems is, the first 5 people that have this violation get a verbal warning, and the 6th person that has the same violation gets terminated. And it just so happens the 6th person just filed a workers' comp claim 2 days ago. Never mind the rebuttal presumption they've got. Now they've also got evidence that you're not treating them consistently with how you discipline these types of things. So be consistent in your discipline for infractions. Certainly some infractions are more serious than others. You don't need to give a verbal warning for somebody that, sexually harasses a coworker. Somebody touches a butt, go ahead and ring them up for it. You don't need to give them a verbal and say, hey, we don't do that around here. You can jump to serious infractions, and you probably want to jump to serious discipline for certain things because it does subject the employer to more liability than perhaps somebody showing up late, that kind of thing. So be mindful of that in progressive discipline. If you do engage in PIPs, be careful of a couple things. I call them pitfalls, again, because I'm a dad. So humor my puns here. What you want to avoid is subjective milestones. What I mean by that is if you just, if we're talking about somebody whose reports haven't been timely, and we just tell them you need to improve your timeliness for filing of your reports. What does that mean? How are we going to measure that? Who knows what that means? He might think it's more timely because he's improved it. We might think it's not timely enough still, so don't use subjective milestones, use real milestones that they can actually meet. Don't fall in love either with absolute standards, right? Ensure every single report is timely filed. They miss 1 out of 100 99% of them are filed on time, and they had one that was an hour late, you're going to fire them for that, or if you want to keep them at that point, you've basically, gone away from what your PIP was, which is they're not meeting the standards, yet you're still going to keep them. So now when I try to say that you've gone back, you've reverted, and now you're doing that again, and that's a big deal. Well, it wasn't a big deal when I wasn't doing what you wanted me to earlier with respect to those reports. So, be wary of absolute standards. And be wary of vague standards, kind of like the subjective milestones, the vague standards of, be better about turning in your reports. What does that mean? Be better. Like I turned one more in than I did last month. Is that better? Is that better enough? From the employer standpoint. So, instead, try to be specific about what you want to see. Maybe you say, we need you to ensure 80% of the reports are completed and submitted by 5 p.m. every Friday. That's a very measurable thing. We can measure that. We know whether this employee has done that or not. And the employee can't say, well, I didn't know what you meant. I did improve. What do you mean? Well, did you have 80% of your reports completed and submitted by 5 p.m. on Friday? Well, no, I didn't. Okay, well, that's why we're letting you go. Clarity is your friend here if we're going to be using performance improvement plans. When it comes time to terminate, what you're going to want to do is first and foremost is check the file, because if you call me and say, hey, I'm going to terminate this person, is that cool? Do I have any issues here? I'm going to say, well, what's in the file? Have you disciplined this person prior to this incident? Is this the first offense for this individual that's worked for you for 20 years? Is termination, why do you want to terminate this person if it's the first offense in 20 years? It's a fairly minor offense. We'll talk about that. What kind of training do they have? Is it something that they were trained how to do and they've not done it? Conversely, if it's something they've never been trained on and we're saying you didn't know how to do this, they're going to say, well, I didn't know I was supposed to do that, or you never told me how to do that properly, or how to do it the way you wanted it done. That's going to cause potentially some issues. Same with have they engaged in protected activity recently, right? We talked about the new 60-day rebuttable presumption. Did they engage in protected activity within the past couple months, such that we would have a rebuttable presumption we have to overcome of retaliation for that. These are all important things to understand as you're trying to decide what actions to take. You also want to confirm what the employment status of the employee is. Are they at-will employees? That's the default rule in Oregon, right? Is at-will. You don't have to give a reason for termination. I often say it's not a bad idea to give a reason. And the reason I say that is because, I always equate it to, it's like junior high, right? And you've got this relationship and you're dumping this person, in junior high, some kid dumps another kid and you give them oh, it's not you, it's me kind of excuse. And everybody knows that that's not a real reason. And they're going to come up within their head what they want that real reason to be. And it's probably going to be way worse than whatever your reason actually was. I just don't like you anymore. You're kind of a jerk. Whatever it is, if you don't give them the reason, same in the employment context, right? If you don't give them the reason, they're just going to assume it's probably some unlawful reason. And the people that end up suing their employers aren't necessarily the people that are super savvy with respect to employment law. They're the people who are just upset with the way the employment ended. And so if they think, you're not being truthful with them, you're not being honest, they may be more likely to go talk to an attorney about it. And so be mindful of that. I know sometimes people, try to pull their punches a little bit and kind of say, well, I don't want to tell him he's a jerk. So I'm just going to say he's a bad fit. And that's the employment. It's not you, it's me is bad fit. I think, it kind of reminds me that Seinfeld episode where George Costanza is getting dumped in the cafe by that woman. And he says, you're giving me the, it's not you, it's me routine. He's like, I invented it's not you, it's me. Nobody tells me it's them and not me. If it's anybody, it's me. Right. But, that's what bad fit is, because bad fit doesn't tell me anything. If bad fit is that they're, argumentative with their supervisors. Why don't we say that? Why don't you tell them they're argumentative with their supervisors and they don't respond to, constructive criticism, and they don't respond to, coaching for improving their performance? Why do we just go with bad fit, right? It might lead to something, but at any rate, confirm their employment status. They're at will, less restrictions on what we have to do, what hoops we have to jump through to terminate this person. If they're a contract employee, we got to look at that contract. What does that contract say with respect to terminating employment? Do we have to give notice? If we don't give notice, do we have to pay a certain amount of money? It's important to know what the contract requires. And then again, if they're a union employee, there's probably a collective bargaining agreement that governs discipline and termination. And we got to make sure we abide by that as well. Maybe it requires just cause. So do we have just cause based on what the discipline is that we're trying to take action for here? And consider a severance package for risky terminations. If it's a risky termination and, you don't feel good about it, maybe you don't have EPLI coverage, employment practices liability insurance, which covers unlawful termination lawsuits and that type of thing, consider a severance package with a release. We'll pay them a couple months of severance in exchange for them signing a release document that basically says they're not going to come back and sue you. And so those types of things are things to consider as you look at whether or not to terminate an individual, based on failure to correct performance that you've done a great job of documenting and you tried to manage, and they just simply can't cut it there with your company anymore. The last section I want to talk about before we get to the Q&A, and I know we're coming on 10:30, so we'll just go through this, fairly swiftly. Of course, during the Q&A, if you've got additional questions about it, feel free to put them in the Q&A in the chat, or rather the Q&A, I guess, and we'll be happy to address those, as they come up. But with respect to, continuing COVID-19 stuff, what still is out there, right? We've got the governor pulling back the executive order declaring a public health emergency. So what still survives right now? What are we obligated to do, and what can we stop doing if we have been doing it, right? And so the enhanced sanitation and those types of things that perhaps you've been doing, if you haven't already dialed them back, you're not obligated to do that anymore. Some people are voluntarily doing that because maybe it makes the employees feel safer about returning to work. Maybe they just like it. Maybe they've got a lot of product they have to use up, maybe they were hoarding toilet paper or whatever. I don't know. Maybe they've got all the sanitizing wipes they just need to use up. But what still remains is that you have to, even though you're not required to mandate face mask use in the workplace like we used to have to do, you do have to allow workers to voluntarily wear face coverings. And the employer has to provide them at no cost if the employee doesn't have one. And so, this is the kind of thing where you want to be cautious about mandating, hey, take that face covering off. You're customer interfacing, you're interacting with customers. We can't have you wearing a face covering. That's going to be a potential issue, right? So if a worker wants to wear a face covering, you have to allow them to do so in the workplace. Otherwise, you're potentially subject to a violation of these rules. You also, if you're going to administer or require some type of COVID-19 testing, you'll have to cover the cost associated with that. So if you're going to still maintain, you can still maintain all those policies that we might have had. Perhaps you had a mandatory vaccination policy. You can still have that. There's nothing that prohibits that. Perhaps it provided a carve out for individuals who didn't want to get vaccinated, had to be tested weekly or something like that. If you maintain that, you have to still cover the costs associated with that testing, including time and travel to wherever that testing facility might be that they need to go to. So be mindful that that's still there. If you're going to require an employee to get COVID-19 testing, recall that in Oregon, we have a statute that requires an employer to pay for any type of medical certification that they require an employee to provide to them. And so, be mindful of that. There also are exceptional risk workplaces that still have mask and sanitation requirements. So if you happen to be an exceptional risk workplace, these are obviously like medical or healthcare settings, type of things, residential care, assisted living, nursing home type facilities also are exceptional risk workplaces where they still have to require masks. They still have to sanitize routinely. Employers that deal with, post-mortem type stuff or transporting human remains, those types of industries also exceptional risk workplaces. Personal care activities, in-home care type things, also, considered exceptional risk workplaces, even though they might be in a home. They're exceptional risk activities where they still have certain mask and sanitation requirements. So be mindful of that. Again, employers are allowed to have, as they are with any law, the law is the floor. You're allowed to have more restrictive policies and such, and more protective policies other than what the law requires you to do. And so if you want to take additional exceptions to provide, more safety or what seems to be more safety to workers, you're allowed to do so. But this is the floor of what you are required to do as well. And so, again, this, the COVID-19 monitoring, reporting to OHA and those types of things are all, gone as of now. Doesn't mean you necessarily shouldn't encourage employees who perhaps come down with a COVID-19 case to stay home for the requisite time period and that kind of thing. But, you no longer have the reporting requirements there as well. But, again, if the cases start ticking up, who knows what may come back there as well. But ultimately, these are the regulations that remain in place. You might have seen this. We being my law firm, Barron Liebman, did issue one of our electronic alerts on this topic, I think yesterday, actually. So if you're signed up for that free service, you probably already saw that. I'm not telling you anything you don't already know, because I'm sure you read through that with bated breath, looking at what we were saying. But ultimately, if you aren't on that list and you want to join that list and be in the know with our electronic alerts that we send out when important things happen that we think employers should be aware of, just send me an email with your contact information. I'll be happily forward that along to put you on the list so that you can receive those alerts going forward. Another question I get a lot with regard to COVID-19 is with respect to working from home. A lot of people, have been working from home for over a year, some close to 2 years at this point, right? And so people are trying to figure out, what do I do with my employees? Can I require them to return to work? Absolutely. If you want them to be in the office, tell them how to come back in the office. You are allowed to require that. Now, what if they don't want to do it? Well, it depends on why they don't want to do it. If they say, well, I'd rather work from home, that's not a valid concern. If they say, I'm concerned about, contracting COVID-19 because I am immunocompromised and can't get vaccinated and this and that, then we might have to look at potential accommodation issues, right? And so remote work might be requested as an accommodation for some individuals. So if you are requiring a return to the office, be mindful that somebody may be requesting an accommodation, allowing them to work from home remotely, full-time, part-time, whatever it might be. And so you have to analyze those as you would any other type of accommodation. Keep in mind that as if the undue burden argument wasn't already hard enough for employers, that if you're going to say working from home is an undue burden, I'd like to see some really good documentation showing how ineffective they've been over the past couple of years, because they've been working from home for 2 years. And that's what they're going to say is, I was allowed to work from home for 2 years. So if you're going to say you can't work from home because you aren't effective in getting your job done, hopefully you've got some documentation, some empirical evidence that the person's work has suffered. And that's one of the most difficult things about remote workers, is making sure you supervise those remote workers adequately, and provide feedback, provide coaching, provide discipline to them when they're not actually doing their job. And I get that it's tough to kind of know what people are doing at home when you don't have a supervisor that's walking by their office or checking in on them physically. But it's important to continue to hold those employees accountable, even remote employees, because you may want to argue that you're not doing a good enough job remotely. We need you here in the office. And certainly there are certain industries or jobs that benefit more from the in-person interaction and the requirements to be there. And that'll be easier to articulate than, perhaps somebody who just does data entry. Why can't I just type into my Excel spreadsheet from my home office? You're going to want to be able to articulate a good reason, to deny that accommodation if you're not going to grant it if they do request it. And some people, are looking at hybrid models anyways, because perhaps it provides a competitive advantage. If you have good talent that you don't want to lose, particularly in this economy where sometimes good talent's hard to replace, you want to look at, them potentially leaving if they can go find a job that's going to allow them to work from home more often than you are. And so some people are going hybrid models. Some big companies are going hybrid models, come back to work 3 days out of the week, you work remotely 2 days, those types of things. So those are all, things to keep in consideration in the working from home, but just be mindful that you might get some work from home requests if you require everyone to return to work, and you may get remote work accommodation requests periodically going forward anyways, even if everyone is back at work now. Let's say, case counts rise, and particularly in a certain area where your business might be located, and the employee again says, well, I'm pregnant and immunocompromised and all these things. And so I don't feel safe in the workplace with all these, the case counts being what they are. So I want to work remotely for, 2 weeks, 4 weeks, whatever it is, until the case counts come back down. That might be a temporary accommodation that perhaps needs to be granted, but you should engage with those employees as you normally would for any other accommodation request. And so if you have issues or questions about that, accommodation issues are sometimes fairly sticky. And so, again, if that's, you find yourself in one of those, you're not really sure what to do, you can always, call up your friendly employment law attorney and say, hey, here's what's going on. I need some advice here. What do I do? I'm not sure how to navigate this situation. So, be mindful of those types of things. But that's one we're seeing some employers struggle with as they figure out how to bring everybody back into the office and or allow some people to work remotely and that type of thing. So with that, I see we got about 20 minutes. I'll leave the rest of the time for a little Q&A for you. But here's my contact information to the extent you want to reach out and shoot me an email. If you have a question that we don't get to today during this Q&A, you're free to, shoot me the question via email, and I'll get back to you, as time allows with regard to a response.
Thank you, Sean. Wonderful information. So we do have some questions. Since we just touched upon this, one of the follow-up questions was, so if it's not a good idea to say it's just not working, it's not a good fit, that always seems safer. How would you suggest terminating someone, if it's something related to personality, not listening, you're acting rude? What recommendations do you have for framing that termination?
Yeah, I guess, again, I don't want to be an absolutist, so don't say bad fit, but just don't go to that as your default reasoning. I say, what are we going to argue? If you get sued on this, what are you going to argue? What are you going to say there's a reason you let him go? And if it's because it's a personality clash, is there anything wrong with saying it's just personalities don't mesh? Your personality doesn't mesh with the team. Is there anything wrong with saying that, if that's what we're going to say? Because if we go to trial on this and they say, well, they terminated me because they said I was a bad fit. Okay, yeah, you're a bad fit. What do you mean by that? Well, you're going to have to answer those questions eventually. And so if it's going to be something that will will sound better to a jury, that will sell our case a little bit better to a jury, then I would recommend, going with the performance type of issue or the, behavior type related. Obviously, you don't got to be, you're just an absolute jerk, man, and everyone here hates you and you should get out. You don't have to be so blunt about it, but to the extent it's, if you just say bad fit, and then we're going to expand that, it's actually going to get into some sort of, policy type violations or things of that nature, depending on what's in your handbook with the workplace behavior that's expected. If it is somebody that's a jerk, oftentimes they're rude or disruptive or something like that. We could say rude and disruptive behavior. That sounds like a better reason to a jury, I think, than it's just not a good fit.
Thank you. Along the same lines, a question was, what about when we terminate someone during the introductory period? So I know a lot of people have, say, a 90-day period, don't see them performing in the role, and they don't pass kind of that 90-day period.
So I don't really want to burst anyone's bubble, but the 90-day period doesn't really do anything. Once you hire the employee, they're an employee. And so they have the same protections that any other employee does have. Some people use the introductory periods and they're fine. Oftentimes, introductory periods are used with respect to who gets benefits. Some employees don't get benefits when they're in their introductory period. But the introductory period also obligates the employer to do something, right? It's at 90, if it's a 90-day introductory period, at 90 days, you have to have an evaluation of that employee to figure out whether they're going to continue on or not. And, so it's extra work. It doesn't provide any necessary protections per se. And you want to make sure how you couch it, because you don't want to necessarily imply that if they survive an introductory period, they're somehow a permanent employee or they gain some extra employment protections that they didn't have within that first 90 days. And so really the introductory period is just a time to evaluate, the employee, which you have, even if you don't have an introductory period, is you have that time to evaluate the employee. You can always let somebody go within the first 90 days if they're just not performing. Oftentimes it just functions to give you a reason to check in on them, that everybody knows I'm going to be checking in on you. So it doesn't seem like, unnecessary surveillance or whatever, if you will. But ultimately, an introductory period does not provide any protection under the law, with respect to terminating somebody at 89 days versus 91 days. If it's because of their race, their gender, their nationality, because they filed a workers' comp claim, it doesn't really matter. I still want to see the documentation of that. If you're firing them in the introductory period because they're not performing adequately, what you would expect at 90 days, I hope there'd still be some documentation showing the issues, the performance issues they've had up to that point, so that you could say, yes, it was in your introductory period and you weren't meeting the expectations. Here's the proof of that.
Thank you. One question was, is it okay to send timestamped emails to multiple people, including the employee, to document performance? So send it to the employee, their supervisor, and HR.
Yeah, I would, yes, but be cautious. I would only send it to those that need to know. Certainly if the supervisor was sending something to HR, I don't know that you necessarily need to incorporate anybody else on it if they're just documenting, hey, he did this, she did that to HR, then HR is reaching back out to the employee. If it's something the supervisor needs to know, then certainly, you can bring them into the loop. But it also makes them more likely to be a witness, a key witness, and or potentially an aider and abetter, because it'll seem like they're more involved in the decision. So there could be some strategic reasons you wouldn't want to blast it out to everybody there. If you're having a meeting, oftentimes it's not a bad idea to have a third party present just as a witness, to that. But you do want to be cautious about including too many people on emails or communications, just because you also don't want the employee to feel like you're airing their dirty laundry everywhere. Because again, more often than not, the person that sues is the person that doesn't feel that they were treated very fairly, right? So it's a fair treatment type of thing. And if they feel you're just trying to embarrass me in front of everybody and you're just trying to tell everybody about all this stuff, they're more likely to become agitated and or try to, seek out a reason to, pursue litigation or something like that.
Okay, good question. Regarding the non-competition agreements, the question was, can we have current employees sign a new agreement so that they are bound by new changes?
Not unless it's on a bona fide advancement. So if you have an agreement and it's valid under the old regulations, I would just keep it in place. If because again, there's only two ways you can have somebody sign an agreement that makes it not void. And that's with 2 weeks notice prior to initially hiring them, that a written notice that a non-compete is required, or upon a bona fide advancement. So if they're a current employee and you're not giving them a giant promotion, do not have them re-sign anything because it's just going to be void.
Okay, great. Regarding the wildfire protections, are KN95 masks allowed? Do you know that particular? I know those are usually made.
I don't believe those are certified by NIOSH, so you would need that certification, not I believe that's technically a Chinese certification that doesn't have the same rigorous lab testing, so they may or may not be compliant. So I would go with the NIOSH compliant ones, which I believe are the N95s.
And then related to that is, are there the written programs that are in compliance with these regulations, even though they are still in the process of being enacted long-term?
So I don't have the slide in front of me, so I don't want to misstate it, but the exception to the fit testing and everything, the exception to the respiratory protection standards that require fit testing and medical evaluation and stuff are included in an appendix to the rule, and I've got the URLs to those proposed rules in there that have some appendices and such that have information. But ultimately, I don't know that OSHA has a model policy out at this point as far as what a model policy in compliance would look like.
Because of course that would be the easy button. If everyone can, download a program, make it fit their own company, that would be fantastic.
Sure.
Okay, so regarding the pay equity, so HB 2818, I think on your slide it was talking about some of the bonuses allowed through 3/2022. Someone had a question, wasn't the bonus extended to the fall?
It could have been. I created these slides a little while ago. I'd have to double check my notes. It's possible that they've extended that. It's possible that it will continue to extend until, sort of this job market fleshes out. The issue with those is that many employers have had to resort to those types of bonuses in order to just attract anybody to the job. You've got, jobs, minimum wage jobs that you typically never see hiring bonuses paid for that are now fairly large hiring bonuses depending on location because people need, not to be derogatory, people need warm bodies in there to do some of these jobs sometimes. It's like, we'll pay anybody, a huge amount of money just to show up here day one and stay so that you can actually do this job we need done by somebody. And so, typically, your hiring bonuses were largely seen for, higher ups, upper echelon type jobs. Now they're even down at, minimum wage type jobs have hiring bonuses. And so, in order to make sure that those don't impact, somebody who's already working there, a minimum wage guy you hired 2 years ago, if you pay somebody, a couple $1,000s hiring bonus, that new employee might all of a sudden jump, that old employee that you had here, if you factor that into total compensation. And so it wouldn't shock me to see that extended, and it certainly wouldn't shock me to see it extended again, depending on what the lay of the land looks like at that point, because the pay equity has had some some issues anyways with respect to how these things are litigated and what counts for all of this. So that wouldn't surprise me at all.
Okay. And someone did have a question. Those bonuses are taxed as income. I'm assuming IRS, yes, once they're taxes.
It's just for purposes of pay equity that they're not considered compensation. Yes. So they're still treated as they are, they are bonuses. So they're still treated as bonuses. It's just that they're not lumped into the broad definition of compensation, which they typically are. Your bonuses are typically part of your compensation so that you can't, essentially pay everybody the same rate and then give all the males giant bonuses and not the females, right? And so it's included in that in normal times. We're not in, and we haven't been for the past 2 years, in what we could call normal times. And so during these non-normal times where it's a lot harder to attract and retain employment in this industry, in this workplace in general, they've relaxed some of those definitions to allow those to not count as compensation, so that if I give a hiring bonus to this person, I don't have to necessarily go through and up everybody else's pay rate in order to compensate for that and ensure they're all in the same band for pay equity purposes.
Great, thank you. Regarding the HB 2474, so the Crown Act, HB 2935, with the, I kind of have the question of, what if someone is Caucasian but has dreadlocks, which is considered typically a hairstyle of a different race? Would that also be covered?
I mean, it's tricky. Because it's tricky because, right, you'd basically be singling somebody out based on their race in that instance, and you'd be treating them different based solely on their race. And so it would probably be, I would say it's going to be case by case dependent upon, I certainly wouldn't have a written policy that says Caucasian employees cannot have braids or, anything like that. But, there certainly are some, real world issues with some of this in regards to, maybe it has to fit under a hairnet, maybe, depending upon the workplace and what's required for like sanitation purposes and stuff like that. It may be that you draft it in a way that says, your hair must fit under this, that, or the other thing if it's required for that. But, I'd be a little bit leery about saying, you're Caucasian, so you can't wear that hairstyle. Now, if there was multiple complaints from, other workers that was somehow co-opting their race, or, it could become this bigger issue, but I would be cautious about just taking that approach initially, that, hey, because you're Caucasian, you can't wear that hairstyle.
Yeah.
That's technically considered protective.
I think sometimes people just go in the way of, man, now I feel like we have to allow everything. So someone did have the question about, what about colored hair? Blues, pinks, where we normally want more standard hair colors. Would that be possibly covered under, because it doesn't exactly describe.
Yeah, the problem is, as with a lot of these statutes, is they don't really go into full detail, right? They do say hair color, now is that natural hair colors or because I don't think, neon green would probably fall within the definition of protective hairstyle, which includes hair color, because that's not a natural hair color. Bleach blonde and some of these others that aren't somebody's quote unquote natural hair color, but are colors of hair that occur naturally, I think are going to be more protective than, like a neon green mohawk or something like that.
Okay, very good. Let's see, some other questions. Someone asked, kind of in general, do you have best practices for how long to retain employee personnel records upon termination?
I would, I guess I'll start by saying it depends what you mean by personnel records. Under the statute, personnel records technically includes time and pay records. And I like to see the time and pay records kept for 6 years because that's how far back you can go with a minimum wage claim. So a wage claim can go back 6 years, depending on the type of claim. And it's way better to have those records than to not have them. Because if you don't have them and they say they worked, they weren't paid for this time and you can't prove they were, you're going to be, in a tough place. With respect to personnel records, like personnel file type stuff, with the new extension of the statute of limitations to 5 years, I would say you probably want to keep them for 5 years, just to make sure. Ultimately, we're probably going to run into a lot of things as time goes by, and then we get to the 5-year statute of limitations. You're going to have a lot of people that aren't there anymore. And the only way you're going to be able to put together somewhat of a defense is going to be what's written in that file. And that's, again, why documentation is so important, because 2-3 years from now, that supervisor might not be there and they might not recall what happened 2 or 3 years ago. But if they have written down that they disciplined this individual for X, Y, and Z, that's going to exist and survive. And therefore, that's going to be the evidence that we relied on, instead of everyone trying to sit here 4 years ago and recalling what exactly was said in a meeting.
Perfect. And we had a question about where can I find additional information about employer responsibilities when requiring return to work medical releases for non-work related injuries and illnesses?
I mean, either an HR consultant or an employment attorney. I guess I don't know offhand. I mean, you could go to Boley and see if they have anything, but I would just call, either the HR consultant you work with, an employment law attorney or something like that. And with your specific questions, I'm not aware of any, nice treatise on, what's required. It'll sort of depend on what it is. It could potentially get into ADA stuff, depend on the injury or the medical condition. It's not a workers' comp issue. Is it FEMLA? Is it OFLA? Sort of depends on whether they're eligible or not. So there are a number of potential leave laws that could be implicated on that. And so it's best to probably run the questions by either an HR consultant you work with or an employment law attorney to avoid potential liability.
Okay. And then I think this is our last question. Are employers allowed to offer incentives to those employees that do not sign up for health insurance with the company? So they're maybe have coverage elsewhere. Some people offer a monetary replacement.
I mean, it depends. Again, that's one that it's tough to have a bright line rule of yes or no. It depends on what you're offering and what the keys to the incentive are, because it's also potentially incentivizing people to not sign up. It's one thing to give someone a replacement because they're not seeing the $100 benefit from, getting those benefits because they have it through their spouse. It's another thing if it's $100 payment to encourage people to not have the insurance and just go uninsured, and so it'll depend on the circumstances of what that incentive is. And I encourage you to run it by an ERISA attorney, employment law attorney that does the benefits stuff to make sure you're in compliance if you want to offer some type of incentive related to benefit health plans.
Great. Well, thank you. That is all the questions. So I think we can conclude our seminar today. Thank you, Sean. So everyone who registered will receive an email. Sean will be sending out the presentation slides, and then BBSA will be following up with everyone as a thank you. If you have any questions, just know your resources. Sean, of course, is available to reach out as a client if you're not already a client of Sean's, or your BBSA HR consultants if we work with you. If we don't, we would love to work with you in the future. So please reach out to BBSI. And thank you for the Chambers for helping us put this wonderful event on.